As we've said, police officers are the ones that lay the charges. They're also the ones that determine whether or not the charges and the seriousness of the offense mean that they need to hold the person for a bail hearing or they can be released from the scene. So the acronym PTR, pre-trial release. Will the person be released from the scene, or are they going to be held and taken to court for a bail hearing? Police in Ontario lay their own charges without consultation from the Crown. In some provinces, including in BC, the Crown's pre-screen charges, and in some cases they'll screen them out and the person won't be charged. Here we don't do it that way. The police lay a charge, and then after the charge is laid, the Crown screen it. In some cases, the police may decide that although a person they have reasonable grounds to charge a person, they may decide to exercise their discretion and not lay a charge if the person was suffering from a mental illness or some other medical issue, and that can be addressed by them going to the hospital, either for psychiatric assessment or for treatment. So there is some discretion, but with respect to more serious offenses, I would say that discretion is virtually non-existent, and in most cases police would err on the side of laying the charge. Looking at the sections for bail hearings, that is really found at 515 of the Criminal Code. It's a very important section. It'll definitely be on the exam. And it talks about what the kinds of conditions are that a person can be released on when they're released by the court, and what the factors are that the court should consider if they're running a bail hearing. And so 495 starts with the police powers to arrest and moves all the way through to what a bail hearing should look like, what the factors are, what the test is, and that's all covered within those sections. The police powers to release someone are important to know, and we're going to go through them now. Okay, so under 498, that is your more minor offenses, absolute jurisdiction of the OCJ. Police officer can release the accused person at the scene with issuing what they call in Toronto a Form 9. It kind of looks like a ticket, almost like a traffic ticket, and it's an appearance notice. And those less serious offenses, the Criminal Code says the officer should release the person. So assuming that at the scene, the person identifies themselves, the officer's satisfied with the person's identity, they don't have any concerns that they're lying about their name or some other problem, and they're not concerned about the safety of the victim or preventing other crime, the police officer can just release them from the scene pursuant to 498. The police officer has to go before the justice of the peace and swear the information, like we said, and that approves of the charge and gets the charge proceeding before the court. Now, remember, during COVID, police are not actually doing that, going in person. These forms are all done electronically. In more serious cases, or sort of on the borderline cases where the person may need to be released on conditions. Just to go back, one more important point about this is if you're released on a Form 9, it just has a court date attached to it. So you are given a notice, it has your name, it has the charge, and it has a court date. There are no conditions on this form of release. Let's say it's a little bit more serious. You can be released by the police without a bail hearing, but they may want, the police may have some concerns either about your identity, or maybe they need to investigate something further at the station, or there's some conditions that they want to impose. That's covered under these sections, so 497 through 499. Remember that under no circumstances can you ever be released from the station on a 469 offense. And I'll explain a bit more about that. So police officers can release someone on conditions from the station. And when we use the acronym OIC, that's officer in charge. So anytime you have a shift of police officers at a station, there's always one officer that's in charge of the whole station. And that's the person who speaks to the accused and gets them to sign off on their release when they're released. And so the officer in charge can release a person from the station if the person themselves is willing to sign a release, an undertaking to the officer in charge, saying that they'll comply with certain conditions. If an accused person is not released by the police before going to court, and they have to be taken to court, that means they're being held for a bail hearing. And what that means is the police have to get the person to court within 24 hours of their arrest. That is a strict time limit that's imposed on the police in Section 503. And when it comes to 469 offenses, 469 offenses are your most serious offenses that are in the criminal code. They're in a special class. It's best to just look at Section 469, just know what they are. It's treason, sedition, alarming the queen. That's always a funny one. Everyone makes a joke about that one. And murder. You basically see murder and accessory after the fact to murder as the most common 469 offenses that are laid. That means that although a person will be taken to the provincial court for an appearance, it's an automatic detention order. So they are not getting released by the police, not at the scene, not at their first appearance in provincial court. If you want to have a bail hearing with a 469 offense, you have to bring a special application in Superior Court. Because remember, like we said very early this morning, 469 offenses are the exclusive jurisdiction of the Superior Court because they're very serious. So assume that you are going to have your bail hearing. You've been brought by the police to court within the 24 hours. The Crown prosecutor is supposed to be ready to have a bail hearing for you right away. However, they can ask, pursuant to 516, for an adjournment of up to 3 days for investigative purposes. And that may mean that they need to look into further evidence. There may be more charges coming. There may be all kinds of reasons. The officers want to interview a witness that they think is going to be important, or they're continuing a search warrant. There's all kinds of reasons why this may happen, but it can cause delay. And bail hearings are supposed to happen expeditiously. So we've talked a little bit about 515. Those are your Ontario Court of Justice bail hearings. And if I was to bring an application for bail in Superior Court for a murder, that's pursuant to Section 522 of the Criminal Code. In most cases, especially the less serious cases, it's a Crown onus to show why the accused should be either subjected to bail conditions or detained. That means the prosecution has to justify that why what they say is appropriate. And the court can hear a lot of information in a bail hearing that may not be acceptable and admissible in a trial. And that means that the prosecution and the prosecution can lead and the court can hear things like hearsay evidence, things that the police have found out about the person, whether or not they're on other charges, all kinds of information like that. The court will then have to decide if the person should be released on conditions and what those conditions should be, or whether or not they should be detained. We'll talk a little bit more about that, but our society is definitely moving towards a place where being released is supposed to be the presumption. Unless the Crown shows why you should be detained, you should be released. That's what the law says. And we're moving in a direction where the courts are being told, especially the lower courts are being told by the Supreme Court of Canada, that we need to move to a place where accused people are released. They're presumed innocent. We shouldn't be warehousing people in jail while they're awaiting their trial. And it was a really good thing to see during COVID. Criminal lawyers all across the province and the country worked hard to get people out of jail during the pandemic so that people wouldn't be subjected to coronavirus. And a lot of people were released, a lot of use of ankle monitors and conditions to make sure even if you were charged with a serious offense, you had a meaningful access to your right to bail. Now, a reverse onus is a little bit different. There's certain kinds of offenses, indictable offenses, like robbery with a firearm, that are reverse onus. It means that instead of the Crown having to show why you should stay in, you have to show why you should get out. And that reverse onus means that you now bear the onus of showing the court all the reasons why you should not be detained, why you should be out. And so this kind of moves the onus onto the accused and shifts that burden. Now it's presumed that you should be detained. And the reason for that is this reverse onus provision. It only applies to offenses that are so serious that we need to protect our society. And so that's the accused has to show on a balance of probabilities why their detention is not necessary.